Hi guys and welcome to today's video. The stage opens with a clash between sovereign citizens and judges who have absolutely no patience left for courtroom fantasy. Buckle up, guys, today we are going to dive into two chaotic cases where belief collides head-on with the reality of the law. This intro sets the tone perfectly, hinting that what follows isn't just legal drama but a full unraveling of sovereign confusion meeting real consequences.
This matter is State of Kansas versus Gordon Cooley. Case number is 24TR65. Are you Gordon Cooley? You'll need to unmute your screen, sir.
Yes, I am the man that is that person.
So you're Gordon Cooley?
Yep.
Very well. State appears by Jill Gillette, County Attorney. Mr. Cooley, there's been an amended complaint filed on, it looks like April 17th. You're charged with driving while suspended as a second offense for on or about March the 25th of 2024 in Elk County, Kansas. If indeed you have a prior conviction where this would be a second offense, that's a Class A misdemeanor. A Class A misdemeanor is punishable up to 1 year in the county jail and a fine not to exceed $2,500. Additionally, with a second offense for driving while suspended, there's a mandatory 5-day minimum sentence. However, a person can be placed on probation from that, but there is mandatory sentence that would have to be imposed. Do you understand what you're charged with?
No, I don't quite understand those no, I don't.
In regards to what you're charged with?
Well, I think this is a matter of a mistaken identity. My persons was never involved in anything. I'm carrying my property from point A to point B. There's no vested interest of the state to even stop me. I'm exercising my God-given constitutionally protected rights, and I stated that to the man acting as the police officer. I didn't present him with the
you are charged, sir. Hold on. You're charged with driving while suspended, a second offense. That would indicate to me that you've had a first offense.
No.
So have you been in court before on this type of charge?
Nope, not on driving while suspended. No, I have not.
All right. Well, that is what you're charged with. You don't have to agree with it. You can certainly, that is an issue at trial if you feel you have a defense. As with the others that I've explained, you have certain rights. You are charged with a misdemeanor, so you are entitled to be represented by a counsel. And if you wish to apply for court-appointed counsel, if you meet the financial guidelines, I would appoint one to represent you. You also have the right to represent yourself. You also have the right to have counsel of your own choosing at your own expense. So at this time, if you wish to have a trial, if you wish to speak with an attorney or counsel, would he qualify under any programs you have since he's charged this as a second offense?
No.
All right. So apparently diversion wouldn't be an option for you. So if you're wishing to have a trial or to speak with an attorney, your plea at this time should be not guilty. If you wish to plead guilty, then we'd proceed to sentencing. But based upon what you're telling me, those would be issues that could be addressed at trial. So at this time, how do you wish to plead?
I don't plan to plea. I guess I'll answer in affirmative if Demers is not acquiesced to quasi.
The moment begins calmly as the judge lays out the charges and penalties. But Gordon immediately drifts into confusion and denial. Alright, guys, now you'll see the tension slowly rising as he rejects even basic legal principles. The judge tries to anchor the conversation, but every answer pushes things further off track. It's a growing pressure point where structure meets stubborn refusal, and the breakdown is already in motion.
If you're not going to enter a formal plea, you're standing mute, and I will enter a plea of not guilty on your behalf.
Okay, I exercise my right to trial by jury then. I'd like to face the man or the woman that claims I've done them harm or law.
Mr. Cooley, If you wish to have a trial by
I'm
jury.
Gordy. I'm not Mr. Cooley. I'm Gordy. I'm a man. I'm not a person.
All right. Mr. Cooley.
Can I ask you a question,
Cooley.
sir?
You need to be quiet for a moment, and I'm going to explain what the situation is. You have the right to be represented by counsel. You've entered a plea, refusing to enter a plea, which is fine. A person can stand mute, and I will set this matter for trial. If you wish to be or have a jury trial, you have the right to do so. However, you need to do that in the proper form. With a misdemeanor offense, you have to file a written motion for that request. Otherwise, it's set before the court. So you would need to do that in a timely way. If you're going to represent yourself, you would have to follow the rules as though you're an attorney. So all of those things would, most people don't have the training to where if they're going to do a jury trial, they're better off being represented by counsel. But that's a choice that you're going to have to make.
Okay, can I ask you a question?
Yes, you may.
Can there be a valid cause of action without an injured party?
Sir, that's not a valid question for what we're doing here today.
I've tried settling this matter in the private twice. If you have any papers in front of you with my signature on them, it's because that is what was required for me to get away from my captor.
Everything escalates here as Gordon launches into full sovereign citizen logic, insisting on mistaken identity, private rights, and homemade definitions that have no place in court. Buckle up, guys. Today we are going to witness the moment the courtroom's patience is stretched thin. Each claim pulls him deeper from reality while the judge attempts to keep control. This is the turning point where confusion transforms into complete legal chaos.
I don't understand what a man thinks that he has the authority to take another man and throw them in a box when they have harmed no man or woman, no claim has been brought against them.
You need to be quiet now. We're going to give you a court date, and you can advise me how you're going to proceed at that court date. If you're going to apply for a jury trial, then you'll need to make that application by that time. Otherwise, you'll be set for a bench trial. That's before the court. Sarah, could you give us a date, please?
What sort of time frame would you like, Judge? 30 minutes?
Approximately 30 days, 30 minutes would be fine.
We can do May 15th at 2:30.
At
Judge,
2:30?
I'm out that afternoon. We could do 11:30 if there's nothing else scheduled there.
We put that for a trial for an hour, didn't we? So
If you only need 30 minutes, we could do the 11 to 12.
well, we said something at 10:30, I believe, or was it the 10 o'clock that was set for trial?
It was the 10:30 to 11:30 that was set.
Okay, let's set this at 11:30 for a pretrial. So, Mr. Cooley, you will need to appear at the courthouse in Howard. And if you're going to file a motion for a jury trial, you need to have done so by that time. If you're going to hire an attorney, you need to do that. If you're going to apply for an attorney, I would suggest that you do that as soon as possible, so that you can have counsel at that time.
Am I going to be able to face the man or the woman that has a claim before me, or are you going to discharge the matter? If there's not a man or a woman here, then this matter needs to be discharged.
Sir, I've heard these arguments before, and those are not legal arguments. Somebody's made these things.
I'm not a member of the legal society.
Sir,
Can we bring the law to the court, please? Can we bring the law to the court?
Mr. Cooley, stop interrupting. At your hearing, if you have motions that you wish to have heard, you can file them in advance. I would strongly recommend you be represented by counsel. But your court appearance is May 15th at 11:30, and you are to be here in person.
I will invoke my common law rights.
Tavius Morris.
I'll come to the jail and talk to you.
Good morning.
Good morning, sir.
How you doing this morning?
I'm well. How are you?
Fine.
Morris had previously, there was one case that I was already representing him on. I don't know that we ever got one on this most recent charge. Okay.
Well, let me see.
Mr. Morris, I know Mr. Hill was representing you in the 23174 case. You're here for an arraignment on the 24 CF49 case. Has your financial circumstances changed?
No, sir.
All right, I'm going to appoint the law officer here, Mark Sims, to represent you in the 24 case.
I go state this to the court.
Raise your right hand and
Yes.
now that Mr. Hill is representing you, you probably want to talk to Mr. Hill before you say anything. We're recording this proceeding, so anything you say may be used against you. But I'm listening to whatever you want me to consider.
I'm not real sure what Mr. Morris is trying to claim in that writing right there. Said he's not a citizen, and
Here, the confrontation peaks as Gordy challenges authority, rejects legal process, and demands answers the court simply can't entertain. Alright, guys, now watch the judge shut down every imaginary argument with clear, firm precision. The courtroom reclaims order, laying out deadlines, procedures, and undeniable facts. It's the moment the fantasy collapses under real-world rules, leaving no room for the theatrics that brought the tension to its height.
something about a secured.
My name is Alizé Morris, a secured party creditor under the UCC-1 filed in Florida. American national being held in custody in Gulf County, which is not a 14th Amendment citizen of the United States, not a record. So documentation, which is official records. To state it, I'm the agent of the said principal.
Who wrote that for you?
I did.
Why do you need to read it if you know what you're talking about?
This memory
Okay. Tell me what the 14th Amendment says.
that you were considered a slave under the 14th Amendment.
That who's considered a slave? I'm not a slave.
No, the incarcerated person. This if you commit a crime
Okay. Doesn't say if you commit a crime.
or yeah.
That's not what it reads.
I got the 14th Amendment really wasn't in the book.
What
Right.
book?
The book that we had in the back.
What book do you have in the back?
It's a law book.
What law book is it?
Florida statute book. Yes.
So the 14th Amendment isn't in the Florida statutes? That's
I
because
was
it's an amendment to the U.S.
Yes.
Constitution.
Mm-hmm.
So you don't know what the 14th Amendment reads.
14th Amendment reads not off the top. Not off.
Okay.
That's
What
why
else
I
do you
written
want me to consider?
that I'm a secure party creditor under the UCC-1.
Tell me what the UCC 1 reads.
I wish I had my documentation in front of me to present it all the way. I wish I had someone here that was supposed to be here so I can have it.
I asked you who wrote that for you. You said you did.
I wrote it. Yes.
So do you know what you're talking about?
Yes, sir.
All right, so tell me what the UCC 1 reads.
It's the Uniform Commercial Code filed with the Secretary of State or within the entities under the contract with the Secretary of the State to maintain uniform commercial code records and database of judgment liens maintained by the Secretary of State.
Now tell me what UCC 1 reads.
It's a statement and it's a financial.
You don't know what the UCC 1 reads, do you?
Not on top.
You're not prepared this morning with your sovereign citizen argument? You needed some additional time to prepare?
Yes, sir.
I'll give you some additional time to prepare your sovereign citizen argument. When do you want to come back?
I would ask that he's got two cases. I know one we've got already got the discovery on that I need to go meet with him at the jail and go over. Being at the jail, I can find time between now and May 9th to go to the jail and take care of that.
All right, Mr. Morrison, you come back. Usually when sovereign citizens come in the courtroom, at least they can recite from memory a lot of the stuff they travel under. So next time you want to come with your sovereign citizen argument, be prepared, okay? I'll listen to you, but be prepared.
Yes.
But you're not doing justice to your fellow traveling nationals who consider themselves sovereign citizens if you're not prepared to even articulate what the argument is, all right?
Yes, sir.
All right, we'll see you May 9th at 1:30.
Today.
Be prepared next time, all right?
Yes, sir.
It should have a constitution in the back so you can read the 14th Amendment and be able to tell me what it reads. And
What it says right here, what is state?
We're gonna, May 9th at 1:30.
Machine into a contract.
That's not a contract. That's giving you notice that you're
Yes,
gonna come back.
Just making sure.
You're fine. I'm not going to query you about what a contract is, but we'll talk about whatever you want me to consider next time. Take care.
The Florida case takes everything even further as a new defendant tries to use sovereign citizen arguments he doesn't understand. Buckle up, guys. Today we are going to watch a judge dismantle every claim, exposing the flaws with sharp clarity. Confidence crumbles quickly when the judge demands explanations he can't provide. It's a masterclass in how reality overtakes delusion. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next video.